Hello, thank you for tuning in. I'm Emily Mullins with Michigan Alliance for Families. Parents and school staff must communicate effectively to plan for students with disabilities. We are here today with our partners from Special Education Mediation Services to talk about collaborative communication in special education. Michigan Alliance for Families is a totally free parent training and information provided all across the state of Michigan. All of our regional parent mentors live where they serve and know about local resources in those areas they're able to share with families. Our goal is to improve educational services and outcomes for students with disabilities across Michigan. Please do not hesitate to reach out to your regional parent mentor with specific questions about your situation. They can be reached at 1-800-552-4821 or through email info@michiganallianceforfamilies.org.
Hello. Thanks for joining to learn more about collaborative communication in special education. This video will provide information on how Michigan's Alternative Dispute Resolution Program, Special Education Mediation Services, can help families and schools learn to better communicate, collaborate, and problem solve over the provision of special education supports and services. Please know that while this video is being provided to you on demand through our partnership with the Michigan Alliance for Families, SEMS is always available to present this information in person to schools, parent groups, community service organizations, and agencies that support families of students who may or do receive special education supports and services in Michigan. My name is Beth Kohler, and I'm an outreach representative for Special Education Mediation Services. Like the Michigan Alliance for Families, we are one of many programs funded by the Michigan Department of Education Office of Special Education, and we frequently refer families and schools to one another for services. I like to share with people a small part of my background with special education. My oldest son was born with an intellectual and developmental disability and received special education supports and services from the age of 1 through the age of 21. When he opted to finish his time in school. He is now successfully employed with a grocery store as a courtesy clerk, living his best life. Let's get started. So since 1997, thousands of Michigan students who receive special education supports and services have been helped by Special Education Mediation Services. We're a grant-funded initiative of the Michigan Department of Education Office of Special Education. And if you take anything away at all from this presentation, please remember that our services are free all the time. There is no cost. You won't get an invoice. They're free. We provide mediation and facilitation and collaborative communication training to schools and families across the state to meet Michigan's obligation under the Individual with Disabilities Education Act for alternative special education dispute resolution. As you may know, Michigan is a birth to age 26 state with regard to the provision of special education supports and services. And as such, SEMS services are birth to age 26 as well. Our overarching goal is to foster cooperation and effective teamwork among those who plan a student's education to help the decision-making process and improve student outcomes. How we help to foster cooperation and effective teamwork is through our free, effective, and fast mediation and meeting facilitation services. In mediation, a neutral mediator helps lead families and schools through a problem-solving process to resolve conflict and come to an agreement on a plan that is focused on the student and their outcomes. With facilitation, we help navigate complex meetings such as IEPs, IFSPs, behavior plans, really any meeting with regard to special education supports and services to help the team members stay on task and ensure all team members are heard equally. This is a good slide that helps summarize the difference between our mediation and facilitation services. We're going to get more into the specifics of each service coming up in the presentation. What is especially important to note is that they are both voluntary processes in which each party wants to be present. To put it simply, mediation services are for when you know you disagree. Facilitation services are when you know you need some help navigating complexity, such as perhaps the imbalance on the IEP team with maybe a single parent and 10 school teaching ancillary staff members around the table. Those meetings can sometimes be really emotional, scary, and just difficult to process. And our facilitators really help navigate those sometimes wavy waters or tumultuous waters. So let's read through the columns in the table, just so you have a full understanding of what each service is about. So mediation, the goal is again to resolve a specific dispute. The mediator establishes the process, and the people that attend are the people that may be in disagreement with one another. And there is no existence of sides. The mediator must remain neutral. Lots of times people misinterpret our services as advocacy services. And it's important to note that our mediators and facilitators are not advocates for the school or for the student. They advocate the process, and they must remain neutral. In facilitation, the goal is that we complete the process efficiently and collaboratively. Sometimes IEP meetings, as was the case for my family, take a really, really long time. There's lots of processes involved or services involved. For my son, because he was fully included from preschool through 12th grade, it was a really complex process, and our meetings took a really long time. And having a facilitator present makes sure that each present level of academic and functional performance statement is reviewed. Make sure that all of the sections of the IEP, our behavior plan are covered. Make sure that everybody at the table who has information to provide is heard. And the difference with facilitation is the process is established by the school. So our facilitators can run the meeting if the school requests that. Otherwise, the school will run the meeting and the facilitator will be a presence to help make sure we stay on task and on time and all the I's are dotted and the T's are crossed. The people that attend a facilitation are members of the special education team, which includes a family. And again, the facilitator must remain neutral. So I want to point out that our facilitators are highly trained neutral. You're going to hear that word a lot because it's really, really important that people understand that the facilitators and mediators are neutral. They're neutral third parties who are engaged to help schools and families. They come from all sorts of professional backgrounds and are not necessarily lawyers. In either process, it's important to point out that in many cases, simply having a neutral outside professional present keeps the participants on their best behavior. So as not to look bad to a stranger who can help them move forward. You're going to see this slide come up a couple of times throughout the presentation, 4 to be specific, as you see there are 4 boxes on the slide, because we want you to fully understand how easy it is to request our services. First, you don't need to know which service you want in order to make a request. Simply reach out using our toll-free phone number or by completing a form on our website, which is listed on the screen. MIKIDS, the number 1, ST.org. So why should you use SEMS free services? You know, a story we like to share is that when former Lieutenant Governor Brian Calley went on a listening tour across the state with regard to Michiganders with disabilities, he kept hearing that schools and families wanted another option to resolve disputes rather than a state complaint or due process complaint or civil court. He returned to Lansing and reported this to the Michigan Department of Education. And then he discovered that we already had such a program. But what we learned is that not enough people knew about it. Thus, our focus on program outreach was enhanced. And over time, we have also centralized our intake process. And as a result, each year we're helping more and more schools and families. So why should you seek out some services? And here's just a few examples of the types of issues that we help with. Perhaps a behavior plan isn't being implemented as was discussed during a team meeting. Maybe there's a disagreement over an independent evaluation. Perhaps there's a personality conflict between a family member and a teacher. Maybe the school wants the student placed in an environment or a classroom that the family disagrees with. When you don't agree with one another is when you should call special education mediation services for help. Or perhaps there are information and communication issues. For example, maybe the family feels out of touch with what's going on with the student's education. Maybe we have a really eager parent and they're texting the teacher at 10 o'clock frequently, and the school wants improved interactions. Perhaps the IEP isn't being implemented as was written, and we need to discuss an improved plan for implementation. Maybe the school believes the student needs specialized instruction, but the family disagrees with that. Simply when you need help finding a solution that is focused on the student is when you should call special education mediation services. Lots more reasons as well, but these are some of the most common ones that we're called about. So we provide services anywhere they're needed throughout the state. It is where the family and the school agree to meet. This could be in person. This could be virtual. The pandemic helped us hone our skills on using technology, and lots of people now are recognizing the value of holding meetings virtually because they're easier perhaps on a working person's calendar. Either way, we'll come to where we're needed. Here's the slide again. So once our SEMS central intake staff listen to the details of your concerns, they'll help guide you on which service is the most appropriate for you to engage in. However, the decision remains yours. So when would we use mediation? Well, when there's conflict, when our needs or wishes are different from one another. And I don't want conflict to be interpreted as argument. Although that does happen, sometimes it's really just complexity over problem solving. Perhaps the team believes the solution to a problem is different than the families. So there could be disagreements over eligibility for programs and services. Again, evaluation interpretations, maybe transition from early on services to kindergarten, to elementary school, to middle school, to high school, and to post-secondary education. Perhaps we have discipline concerns and the team is not in agreement over how to handle the discipline concerns. And of course, over any type of service delivery. And always remember, whenever there's communication or relationship issues, we are really good at helping the teams learn to better collaborate and communicate. And we are also involved in the process, or can be involved in the process, of due process complaints or state complaints. When you complete those forms, you will be given the option to engage special education mediation services in that process as well. We like to say, call us early, call us often. The sooner you engage with us, potentially the easier it is to come to an agreement over a resolution. So we like to do some fact checks throughout our presentation, and here's one. Attorneys and advocates have no role in mediation. While mediation is designed to let educators and parents speak for themselves and develop solutions to meet student needs, nevertheless, in Michigan, attorneys may participate in mediation and have been supportive of the parties in the process in many instances. But you should know that mediators will encourage the family and school to be the voices heard in the room during mediation. So the mediator's role is to remain neutral, to conduct the mediation. They're going to ensure that all parties have equal opportunity to express their ideas and thoughts. Our mediators are really well trained in those silent forms of communication. So perhaps they may notice a person's really eager to speak, but they're not. The mediator is going to pick up on that and really encourage everyone present to participate in the meeting. They're going to establish some rules for appropriate conduct, such as no name calling, no shouting, attention to the meeting that they're there for. maybe trying to keep people from looking at their phones all the time. I know a lot of our administrators have a really tough time because there's so much involved in their day-to-day jobs, but our mediators are going to really request that people remain present, both in the physical sense and the mental sense during the meeting. They're going to help the parties stay on topic of their disagreement, stay focused on the student, guide the participants towards creating an agreement, and they're going to record the agreement. So in a mediation, you can, well, we hope the goal is to come to an agreement, and there's a written agreement that is created that day, hopefully, and where both parties can sign. The agreement becomes a legally binding document. It can be an addendum and serve as an addendum to the student's IEP. It's important to note that the mediator will not take sides. They will not give legal advice. They will not make a decision on behalf of the team, and they do not enforce the decisions that are developed in the mediation agreement. Lots of times people will ask us, so what happens if the mediation agreement isn't being followed? Well, our advice to you is to call SEMS again. We'll convene the team along with the mediator to learn why was the agreement written in a way that can't be followed, and take a look at that and see if they can come up with a better plan. We'd like you to know that we have a really high agreement rate. It hovers between and around 75%. And we're really proud of that. Nationally, if you were to look the statistics up, Michigan is far above the national average when it comes to mediation agreement rates. Our mediators are really highly trained individuals. Again, they don't necessarily have to be lawyers. They can be social workers, educators, community members who are interested in the collaborative process. They go through a really robust training program, followed by what I refer to as a robust internship and period of practice before they may be referred to SEMS for specific training in special education mediation and facilitation. Once they're referred to us, they go through another robust period of training and internship, followed by a lot of continuing education in order to provide the best services possible to our schools and families. So here's another fact check. Mediation agreements are written by the family and the school. This is true. The parties lose none of their legal authority. They remain the decision makers in mediation. The mediator encourages all parties to generate options they may agree to but cannot decide the issues for them. So this is a really colorful slide that describes the benefits of mediation. And we're going to go through each one individually so that you have a full understanding of why we believe this collaborative process is a benefit to schools and families and ultimately students. It's voluntary. So both parties have to agree to undertake the process. They've reviewed the statement of understanding to participate. And we know that when a neutral party is present, everyone's on their best behavior. It's confidential. So it's important to note that all the conversations and notes taken during the mediation are confidential, and even the mediator's notes are destroyed. Participants control the outcomes. This means that rather than the state deciding what should be the resolution, the family and school, the parties most involved, agree on the solution, which is likely far more focused on the student. There's a written binding agreement that's enforceable in court and can serve as an addendum to the IEP. And participants become more self-sufficient. Solutions remain local. Again, rather than the state or an administrative law judge determining what's best, the parties come to a mutual consensus on the solution and will be far more invested in seeing it through. You know that when you're involved in a decision, you're more invested rather than someone telling you what to do or how to fix or solve a problem. And this leads to the team building better collaboration and problem solving skills for the future. And dispute resolution costs decline. So the state complaint and due process filings cost the state a lot of money. A due process filing alone can cost the state $50,000, and that doesn't include what it costs a school, and it doesn't include what it costs a family. So in theory, more time and money can be spent on educating Michigan students rather than in a formal complaint process. Know that that is always an option available to you as part of your procedural safeguards. But we hope that you can reach out to us first and see if we can come to a resolution. And again, I've said this before, but remember, in many cases, simply having a neutral outside professional present keeps the participants on their best behavior. And we really believe that to be true. Here's another fact check for you. Mediation is considered a district failure. Listen, this is false. The Michigan Department of Education Office of Special Education funds our program to help schools and parents resolve disputes at the local level so that they don't have to intervene. In mediation, the Office of Special Education is not at the table. The parties resolve the issues themselves. The Special Education Mediation Services reports our data in the aggregate only. I think it might be the only grant program I've ever been a part of that had a single data set to share. We don't tell them where the cases are from. We don't tell them who's involved in the cases. We let them know that we had this number of facilitations in fiscal year 2023 and this number of mediations in fiscal year 2023. And that's all they know. However, if you do file a state complaint or file a due process complaint, they're obviously going to know because you have to fill the forms out, and that includes your name and the school of residence. So, and also, you know, our Office of Special Education and the federal office prefer alternative dispute resolution processes be engaged prior to those formal dispute resolution options. Educators and parents know their students. They know the resources available for meeting the student needs. And this is why those state and federal offices encourage the use of mediation and facilitation. So you request, here's that slide again, the third time. After we've determined which process is desired, Special Education Mediation Services will contact the parties. If a family member initiates the request, then we will call the school, let them know that somebody is requesting our services and get them to agree to participate. If the school calls us first, then we will reach out to the family and let them know that our services have been requested. Lots of people will ask us, well, what if somebody disagrees? And I will tell you that our intake team is really skilled in special education supports and services, and they do a really good job of letting the parties know the value of the collaborative dispute resolution process. So we find out the date that works best for the family and the school, and then we reach out to one of our partner dispute resolution centers to arrange for a meeting. The Special Education Mediation Services program also processes all of the necessary paperwork. So we're going to focus a little bit more on facilitation now. And lots of people will ask us, you know, when do you use facilitation? What is the point of this? It's important to note this is not a mandatory process under the Individuals with Disabilities Education Act. It is something that the state of Michigan chooses to enhance their alternative dispute resolution program. And so you use facilitation when there's a complex issue. Maybe it's a lengthy IEP meeting like I shared earlier. Maybe they're chaotic. Maybe there's no agenda typically. Maybe, and I know this is the case in lots of our school districts, the whole team is never in the room at the same time. Perhaps there's confusion and fear because special education is a really overwhelming process. These are times when you can call us to facilitate any meeting with regard to the delivery of special education supports and services can be facilitated. The facilitator's role is to receive information about the concerns in advance of the meeting. They're going to acknowledge and review the agenda. Remember, it's up to the school district to determine if the facilitator leads the meeting or is simply a participant of the meeting. They're going to make sure, again, that everybody abides by the rules. They're going to make sure the meeting stays focused on the students' needs. If during the preparation process for the meeting, the facilitator is going to learn about the issues that are important to the parties. And if they discover during the meeting that maybe one of those issues isn't being covered, they're going to point that out and encourage that topic be discussed during the meeting. Again, they're going to keep it on track and on time. And if requested, they'll conduct the meeting. They're not a part of the team. Again, they're not going to give legal advice. They're not going to take sides, and they will not make any decisions on behalf of the team. Facilitators and mediators are often the same people. They have all gone through the same training, and they use many of the same skills in facilitation as they do in mediation. Here's another fact check. Mediators and facilitators are not advocates. I mentioned this earlier. Mediators and facilitators are obligated to remain neutral. Their job is not to represent one side or another, but to encourage both sides to work towards solutions for the student. Advocating for a school or parent could upset the balance between them and make solutions harder to reach. We often tell people if they have participated in a SEMS mediated or facilitated meeting, and you believe that the mediator or facilitator showed a particular bias toward a student or a school, we'd ask that you reach out to our central office and let us know so we can look into perhaps why that was occurring and provide better training. Last time, you're going to see this slide. So now that SEMS has listened to the issues, opened a case, contacted the parties, arranged the schedules, and processed the paperwork, all that's left is for the school and family to meet and work on resolving the issue at hand to help the student. It really is a very quick and efficient process. People will ask us how quickly we can schedule these meetings, and it really just depends. We will do our level best to schedule them as quickly as we're needed. Sometimes we'll get calls on a Friday for a Monday meeting, and we're gonna move mountains to make that meeting happen. We're not always successful in turning it around that quickly, but we do our level best to meet when the families and schools need us to. So we call this the big picture, or the Michigan Special Education Communication Continuum. This continuum is adopted through the National Center for Appropriate Dispute Resolution and Special Education. And we'll go through this bit by bit just to describe the continuum to you. So it starts with prevention, right? So we do, through our office, conflict resolution skills training, communication skills training. There are lots of modules that are available to you if you visit our website. You can also reach out to us directly and let us know what it is that you need, and we'll see if we can develop something just for you. So stage 2 is perhaps there's discomfort, questions, complexity. This would be a great time to engage in facilitation because perhaps you need more collaboration in the special education process. Then you reach stage 3, which is disagreement. And this is when you may engage in mediation, when you simply need help finding a solution to move forward. Stage 4 is when you would engage in procedural safeguards, right? So that could be mediation under the Individuals with Disabilities Education Act. It could be a state complaint, a due process filing. Part of a due process filing is a resolution session, can be used. And then stage 5 is a legal review of litigation and legislation. So when you look at the continuum from the left to the right, the left side is where you have more involvement. You're part of the process. The more you move to the right side of the continuum, the more someone else is going to have the authority over the decision being made and what the ultimate solution will be. It's informal and flexible on the left. It's formal and fixed on the right. Think of Supreme Court decisions, right? So a case is heard and these individuals get to decide what the resolution is to that issue. All stages of the continuum are available. All right, next slide, let's see. Again, I mentioned communication workshops. These are some possible workshop topics that we offer. We will go all over the state. We can present over Zoom or Google Meet or whatever tool is necessary for the participants. We do collaborative, as I mentioned, communication skills training. We do training on effective IEPs, engaging families, conflict resolution. We've built some presentations on developing trusting relationships and how to communicate with the most challenging personalities, manifestation determination review processes, counting suspension days. We have a highly trained and experienced staff that can customize training to meet just about every need dealing with communication, conflict, and special education. Simply visit our website and complete a form or call the number 517-334-0034 to learn more about those options. Here are ways you can stay in touch with special education mediation services. We have a quarterly newsletter called the Communication Connection, and you can visit our website and there is an option for you to sign up to receive that newsletter quarterly. We also participate in social media on Facebook, and you can follow our Facebook page, or you can visit our website to learn about the many options we have available for you and the information that we have available for you. So throughout the presentation, we provided many different ways to explain special education mediation services, but I think this is the easiest way to remember. We're free, we're fast, we're confidential, and we couldn't really figure out a cool icon for effective. So we're free, fast, confidential, and effective. And we're results driven. We like to improve communication and relationships, create safe spaces to problem solve, build collaboration skills, and improve student outcomes. And remember, we're in the high 70s success rate for resolving disagreements between families and schools. So this is how you contact special education mediation services. You can call 1-833-KIDS-FIRST, which is 833-543-7178. You can visit our website, or you can email us at info@mykidsfirst.org. And of course, you can always contact the Michigan Alliance for Families if you forget any of this contact information, and they will refer you to our office. Thank you so much for tuning in today. I hope the information was valuable. Again, please reach out to the info@michiganallianceforfamilies.org with any questions you may have about this presentation. And I hope you all have a great day.